Hello, my name is Reverend Dr. Mae Elise Cannon. I'm the Executive Director of Churches for Middle East Peace, and I'm pleased to welcome you to this webinar called Document Detention, Justice for Palestinian Children. I'm eager to introduce you to our two guests this morning. One is coming to us from Palestine. Are you in Ramallah, Farah?
And Jerusalem.
In Jerusalem, yes. So one of our guests is coming to us from Jerusalem, and then Brad Parker is joining us from New York City. So welcome.
Thanks for having us, Mae.
Thank you.
I'd like to introduce a little bit of your bios and then have each of you take a few minutes to talk a little bit about your work. And the way that this will progress is we have an hour together. It'll be very discussion-based, very discourse. We'll give the people who are watching the opportunity to be able to ask questions directly. So let me tell you a little bit about Farah and a little bit about Brad. Farah, I got your last name wrong.
Farah Bayadsi, it's okay.
Bayadsi, Farah Bayadsi. It almost sounds Italian. She's a lawyer for Defense for Children International-Palestine. She provides legal aid to Palestinian children detained by Israeli forces and prosecuted in Israeli military courts. Farah specializes in issues of juvenile justice and speaks on the situation of Palestinian child detainees. Specifically issues of ill treatment and torture of child detainees within the Israeli military detention system and violations of international humanitarian law and international human rights law. So welcome, Farah. We're pleased to have you with us.
Thank you, Mae.
And then Brad Parker has been a friend to Churches for Middle East Peace for a long time, and he and I have worked together previously. He's a staff attorney and international advocacy officer at Defense for Children International-Palestine. He specializes in issues of juvenile justice and grave violations against children during armed conflict, and leads Defense for International-Palestine's legal advocacy efforts on Palestinian children's rights. He leads their U.S. programs and is the co-leader of the No Way to Treat a Child campaign, which we'll be talking about some during our conversation today, and is a graduate of the University of Vermont and received his law degree from City University of New York School of Law. So welcome, Brad.
Yeah, great to have this happening today.
Glad you both could join us. Well, Brad, we'll start with you. Tell us a bit about your work, particularly how it plays out in the U.S. context, and then we'll have Farah talk to us more about child detentions and the realities on the ground.
Sure. So, first, Defense for Children International-Palestine, for those that don't know, is a local Palestinian human rights organization. We're the only local Palestinian human rights organization that focuses specifically on children's rights. We've been around since 1991. And were started specifically to provide legal aid to Palestinian children charged in the Israeli military courts. So that piece of our work is still kind of the main component of our programming, though we have expanded to become what we'd say is a full-fledged human rights organization. Kind of in the early 2000s, we monitor and document violations of children's rights throughout the occupied Palestinian territory, regardless of the perpetrator. So for children in East Jerusalem, the West Bank, and Gaza, we have staff that monitor, document a wide range of violations from fatalities, injuries, impacts on the right to education, right to health. So we look at Israeli forces, Israeli settlers that commit violations, but also Palestinian actors. So that's sort of our background, and all of the information that I'll share today comes from that documentation and the work of our staff, on the ground, working in their own communities to monitor the situation of human rights for Palestinian children. We, in 2015, started a full-time U.S. program. So that's sort of my role now with DCI Palestine, is to lead our work in North America and internationally around advocacy to improve the situation of Palestinian children's rights, and also to challenge and hopefully have a small role in ending the occupation and the systemic structures that really allow these violations to continue. So through that, we've been in the U.S. As Mae said, we've had a strong relationship with Churches for Middle East Peace over the past several years, and particularly with Mae previously in her previous role. And I think what we've been trying to do is bring these really compelling, narrow issues, specifically affecting children, to show Americans and people that might not have, the ability to travel to the occupied Palestinian territory, what it is to be a Palestinian child living under 50 plus years of military occupation. What does that mean for that family, that child? And we've done that, I think, primarily focusing on Palestinian children in Israeli military detention, because it's such a clear, compelling issue, and also just so systematic. So maybe I can jump a little bit and just give an overview of the issue, and then Farah can jump in and talk more about what it is to really work and represent these kids in the military courts. So I think first, I'm a lawyer. I think I won't sort of go into tons of detail, but I think it's important to start with the legal framework that applies to Palestinians in the occupied West Bank. So 1967, Israeli forces occupy West Bank, including East Jerusalem and the Gaza Strip. When they do, they institute military law. So military law essentially means that a military commander has executive, judicial, legislative authority over the entire area. To pass a new military order is essentially to write whatever that military commander wants on a piece of paper, sign it, and that's the law that applies in the territory. Under international law, any person located in the territory, the occupied territory, military law applies to them. But what we have is a situation, sort of the basic legal framework operating in the occupied West Bank, is that military law is only applied to the Palestinian population, while Israeli authorities apply Israeli civilian law. So civilian law, is increasingly has more protections, more in line with international standards, something more similar to what we would have here in the United States or in Canada. So the basic sort of starting point is a legal system that discriminates based on whether you're an Israeli settler, an Israeli citizen living in the West Bank, or a Palestinian. So Palestinians are automatically tried in military courts, even though the majority of, in all of the Palestinians charged in those courts are civilians under international humanitarian law. So that's sort of the starting point. And then a couple other pieces about the military law. So essentially, soldiers can arrest anybody at any time because the majority of arrests are carried out on suspicion. Right? There's no real independent oversight over arrests. Warrants are rarely issued. So what you have is a situation where soldiers are empowered to arrest anybody that they think has or have suspicion of that has potentially violated one of the security offenses in the military law. So what are those security offenses, quote unquote security offenses? So the majority of Palestinian children that Farah represents and that are charged in the military courts are charged with throwing stones. So the military law has specific offenses that look very similar to, an American or a state-based criminal code. There's homicide, there's assault, things like that. But you also have sort of more politically motivated offenses. Throwing stones is one of them. So under Israeli military order 1651, throwing a stone, at a military installation, a fixed structure like the separation wall, the concrete separation wall, that carries a potential 10-year maximum sentence. You don't have to damage the wall. You don't have to, you might not even hit the wall. It's really the conduct of throwing that stone that's criminalized under the military law. If you throw a stone at a moving object, that comes with a potential 20-year maximum sentence. So that gives you a sense of the gravity of the charges when it comes to punishment and sort of how the military law works. So the age of majority is 12 years old. So when we're talking about children in the military courts only have jurisdiction over kids 12 years and older. The age of majority was changed several years back to 18. So if you're 18 years old, you are no longer a child. That's the international standard, and that's what the situation is in the military courts. So when we talk about children charged in Israeli military courts, we're really talking about 12-year-old children up to 17-year-olds. The bulk of kids that are charged are probably in that 15 to 17-year-old range. And then, 12 to 14 is the smaller percentage. And then there's sort of a handful, but 14, 15-year-olds in there. There's around 500 to 700 kids each year arrested and prosecuted in the military courts. What this number doesn't necessarily capture are shorter term detentions and younger children. So, for example, in the southern West Bank city of Hebron, you have Israeli settlers and Palestinians living in the same areas. There's a high soldier presence. There's a lot of checkpoints. Kids have to maybe go through multiple checkpoints to get to school. So in these communities, in areas where children interact with soldiers on a daily basis, younger children are more vulnerable to shorter term detention. So a child going through a checkpoint on their way to school might be pulled aside, placed in a container, questioned for several hours, taken to an Israeli police station, detained maybe through the night. But say they're 11 years old, they can't be charged in the military court system, so they'll be released later on to their parents or Palestinian police because they can't be charged in the military courts. And so that figure is a bit uncertain, but it likely accounts for another 100, 200, or even more kids each year that sort of face those more informal detentions. And I guess my last point on the military law that I think is really, really striking is that there is no right to an attorney during interrogation under the Israeli military law. So when we think about what systematic, widespread ill treatment looks like, right? 3 out of 4 kids face some form of physical violence after they're detained, and that's hugely significant. Because what we see is that the military court system, right, it's not about holding individuals accountable for specific conduct. It really is a tool of the occupation to maintain control of Palestinian populations. So when you kind of deconstruct and sort of step back and look at what the military detention system is doing, right, you're arresting 500 to 700 adolescent boys in the middle of the night from their homes, ill-treating 3 out of 4 of them, putting them in an interrogation room where they're essentially alone without legal counsel, where there's little oversight over arrests, right? So if a child's in an interrogation room, that interrogator doesn't have anything to pass to a military prosecutor to charge the child in a military court unless they can get a confession or maybe an incriminating statement from another child. So this is, the goal of the process is really to get that confession, run these children through the military courts, because it works to fragment communities, fragment families, and we can talk a little bit more about the sentencing and the after effects, but it's not a justice system. And I think that's one thing that people think when you hear, even if it's military court, right? The idea of courts in general, I think for Americans particularly, is that there is an interest in justice. And I think, you go to the military courts and you see very clearly that there really is nothing to do with justice happening there. So maybe I'll end there and we can pick that up in a little bit.
Thanks, Brad. We've had a number of people join us since you started. So that's Brad Parker from Defense for Children International-Palestine, and his colleague coming to us from Jerusalem, Farah Bayadsi, who is also an attorney. And so Farah, we'd love to hear from you a bit more about some of the realities on the ground, what some of these cases look like when children are arrested and taken to military court, and after you're done your introduction, we'll have much more of a discussion as well. So I've noticed a number of people have joined us online. We have someone watching from London, for example, and I know someone else wondered if they could ask questions. So they can, if you're watching, you can put your questions in the chat, or you can email us at info@CMEP, CMEP, which stands for Churches for Middle East Peace, info@cmep.org. And we'll be happy to take questions in just a few minutes. So Farah, tell us a bit about your work. You're based in Jerusalem. You work for Defense for Children International. We'd love to hear from you about this reality of Palestinian children being detained by the Israeli military.
Yes, I am Farah Bayadsi, as you have been introduced me. I am a lawyer working with Children International for Defense International for Children's Rights organization. I work mainly in military courts. I represent children in military courts in the West Bank and in civilian courts in East Jerusalem, basically. As my colleague Brad was saying, I will continue my saying as he talked about system of control. Actually, what really happens in reality, it's like a big contradiction between what's written in the law and what is regulated by the law, and on the second hand, what really applied in the reality. What we really we as lawyers, we face a lot of challenges on the ground while we want to represent the children, the Palestinian children. It's in my opinion, the ill treatment and violations of Palestinians' children's rights begins from the very first moment of their arrests. I call this journey of detention for these Palestinian children as the endless hell trip, as I think that this trip begins from the very moment of their arrest and detention by the Israeli forces, and I don't think that it matters whether it was for 1 hour or for couple of months or 1 year. I think that the impact of such arrests on those children begins from the first moment and can continue forever. That's why I call it the endless hell trip. And I can see that those effects and impacts on the children during my representation for them. And the violations of their rights can began, as I said, from the very first moment. The majority of the arrests of those children happen in the early time of the morning, the early hours of the morning, while the children are being sleeping in their beds, and the Israeli forces just come to their houses and kidnap them from their beds. Usually what happens the arrest can be at 3 a.m. or 2 a.m. in the morning, suddenly, without any previous alert from the Israeli forces to the parents, to the family. And what happens that the soldiers and the forces asks the family to all the members of the family to be in one room, so they can find the specific child that they want, and they just arrest him or arrest the child from the house without really explaining for the family and the parents about the reason of the arrest, and without telling the child himself where he is going to being taken to, what interrogation center he's being taken to. So this way and practice that the Israeli forces conduct in almost every arrest of the Palestinian children starts from the first moment. The feeling of the intent to terrify the children and the family members starts from that moment, and from that moment the child is being taken alone without any accompany of any of the family member, and he's been put in a very big metal vehicle, military vehicle, and usually they just put him on the ground, and they don't seat the children on on proper seats. And before getting to that vehicle, the child immediately is being blindfolded and handcuffed with plastics handcuff that usually is very painful, as I hear from the children. And from that moment, the hell journey starts, and the vehicle usually the thing that needs to be happen, that from that moment the forces needs to take the child to the interrogation center directly. But in reality, what happens that those Israeli forces and some of the arrests just stop in the middle of the way during the transfer, and during those stops in military closed bases, the child is being held in on the ground and alone, without any explanation about where is he, why he's waiting such time alone in the outside the atmosphere. And sometimes this circumstances is very harsh on the children during the winter and the very hot summer. And this multi-stops during the transfer to the interrogation centers can take multi hours. So the child is just being put there for a couple of hours, and usually we track the ill treatment. The majority of the ill treatment practices happens in that multi-stops hours, because the child is being held alone. He's been there's no one that can supervision that such detention. And we hear from the children that during that hours they're being humiliated, and they're being verbal abuses being practiced against them by the Israeli forces, along with physical violence. So it's very dangerous, in my opinion, to talk about such multi-stops during the ways to the interrogation, because of course it's against all the international standards in which we supposed to protect the children rights, and also it's against the local standards of detaining a child under Israeli law as well. So and for me, this fact of taking such children into such multi-stops is very dangerous, because you cannot prove such practices, because there's no documentation about such places. There's no hard documentation that I can rely on, or talk about, or support my allegations during so I can prove that the child has been harassment or ill-treated. So the documentation about such arrests by the Israeli forces is very lacking. It's very unprofessional, and we face such challenges in the court halls. So the lack of documentations make our allegations to be much harder to be to prove them. So and after the multi-stops, if any during the child detention, supposedly that after this multi-stops the child is being taken to the interrogation center. So we can see that the journey starts from the transportation, illegal practices during the transportation of the child, ill treatment, physical and verbal abuses, and then the child arrives to the interrogation centers. Unfortunately, in the West Bank, especially, the interrogation centers are located in military closed bases areas. So the entry to such bases is very tiring, and it's accompanied by a lot of procedures. So you can have the access to go to such police and interrogation centers. I don't say that all the interrogation centers are like so, but there's a couple of interrogation centers like Asion Interrogation Center near Hebron city, that a lot of children are being taken to be interrogated there, and it's located in a military closed area. And when I say military closed area, meaning it means that only militarized people are have the access to be in, and if anyone, any other civilian, including the lawyers and me, myself, need a special approval to enter such such entity. So this is another challenge that we face, because putting such children in detention inside such closed military areas uphold us to give the fastest legal advice and the consultation to the children, and sometimes it uphold us to even reach the children. So in many cases, as Brad said, that access to a lawyer is almost impossible under such detentions, and it's very also crucial point to protect the children's rights, and again it's against the dual and a fair trial standards under the international standards and law, and it really affects the psychological feeling of and the feelings of the children during their detention. It's because, as I said, that he's been taken alone without any family member, and it continues until he enters the interrogation centers and rooms, and during the interrogations there's no any family member present during such interrogation in the majority of the cases. Unfortunately, what happens in reality that the Israeli forces has use the exceptions of the law as the general norms those days. In the law, there's a couple of extensions that allow the police to extract and a couple to like prevent the presence of a lawyer during the interrogation, and other and to use other norms with children in different way. But the Israeli police unfortunately use such exceptions as the general policy practice in almost every cases, and the reasons that they gave to such practices is very general, although the law is very strict about reasoning such use of exceptions and to write such reasons. prisons, but we see in court halls that such exceptions are being used like in almost every case without any explanation and appropriate reasoning by the police commands in chief about why did you prevent such parents to be present in the child interrogation. Usually they claim that such present can affect the interrogation interest, but I think that it turns to be as a policy, not as an exception of the law. And it's very obvious. I think that the target of such arrests in such early age for Palestinian children aims, and the first aims to terrify the children and to criminalize such children and put them in a criminalization circle where they can where they can feel unsafe and they can be unattached to the outside environment that they live in, and this what's really happens with the children going through such terrifying experience, even if it was for 1 hour or a couple of hours, or even if it was for a couple of months. The interrogation tactics and coercive measures that the Israeli police uses during the interrogation is very terrifying to a child under 18. Disconnecting the child from the outside world by blindfolding his eyes and handcuffing his hands, stopping, putting him in multi-stops, open areas without any explanation. And we don't need to forget that during this detention, the children don't really understand the language that they're being talking with, because that soldiers talk Hebrew, the prisoners and the children talks Arabic, and usually during the detention itself, in the houses, the transportation, the interrogation are there's no formal translator that can be rely on, so he can translate it right. What happened in general, they have a militarily approved translator that translate the court sessions, let's say, inside the court. And in the interrogation, the interrogator needs to talk Arabic, so he can interrogate and conduct the interrogation in Arabic. But let's say in Asyon interrogation center, the interrogators are Jewish but speaks Arabic, so you can feel the language obstacle during the interrogation, because the law is very strict about having an interrogator that speaks fluently Arabic as a native language, but a lot of interrogators are simply Jewish and learn to speak Arabic, which makes the interrogation much harder than it's supposed to be. So during the interrogation, a lot of tactics are being used, so the interrogation can obtain a confession illegally. Sometimes a lot of coercive measures are being held inside the interrogation centers. It can be it can be verbal measures, physical measures, tactics, lies, and threats from the interrogators to the children. I recently visit. I just in this morning I visit a child inside the Alpha prison, so I can have an affidavit from the child after he was arrested, and he was arrested in this month, and he told me that he was threatened by the interrogator, so that if he will not confess, so the interrogator will assure to him that his father that owes an approval to entry Israel, that such approval will be withdrawn from his father. So this threat is very dangerous, very risky, taking advantage of such points and of the children feelings and threatening them and their families, using very harsh tactics and language against them is very systematically done by the Israeli forces. We see that the abuses are not just frequent, is rather than they're being used as a routine by the Israeli forces. So we can feel that it's a systematically abuses and practices used against the children, and we know. I want to complete the detention process after the interrogation room. The children usually needs to be taken in front of the judge. Unfortunately, in the West Bank, the period of bringing the child in front of the judge is only was changed only recently, this beginning of this year, which the Israeli military prosecution changed it and make it more shorter than it was before. It was the time of bringing the child in front of the judge was 48 hours. Now it's 24 hours, so it's better, but it's still not enough, in my opinion, because it depends on the age. If it's it's complicated, but still it's a long time or a period of time that the children is being held alone. And we usually, as lawyers, we meet the children first at the court halls. I remember the case of Fawzi Jinedi, for example. I saw him and I knew him by the picture 2 days before I met him personally inside the court hall, and it was very sad and strange. And it's very dangerous because in Fawzi, let's say Fawzi's Jinedi's case, and I'm talking about the child who was captured while he was dragged away with more than 20 soldiers around him. He was arrested last December after the declaration of Trump about that the Jerusalem is the capital. So he was physically injured, and he had all bruises all over his body, and he had a broken shoulder because of the violence that was conducted against him during the arrest. So the limitation of time that we face, and we feel that the military forces wants to prevent us to see the children right away after the arrest, makes the documentation of the violation more harder on us, so we can use them to prove our allegations. Meaning that if he had a bruise one day before, it may goes away when he gets to the court. So A lot of attempts, practically attempts, like on the ground, we face, so the documentation of such violation will be more limited than it's supposed to be.
Which actually is why we're doing the webinar. I mean, the webinar, we're calling it Document Detention, and one of the things I hear you talking about is how difficult it is. Yeah. You know, the actual experience of these children, and then the documentation is such a great challenge. Yes. So we're going to have lots more time, Farah, as well, for you to be able to answer some questions. But you've been talking about so many things. I want to ask a couple of questions about things we've talked about so far. And then, Brad, we also very much want to talk about what's happening in the U.S. context, particularly with the McCollum legislation, some of the work we're doing together on Capitol Hill, and how we're seeking to respond to these challenges and this treatment of children. One of the questions is, my understanding is the UNICEF reports over the last several years have used 3 terms that have been, and I think you've been using them: systematic, widespread. What's the third term?
Institutionalized.
Institutionalized.
Yeah.
Can you talk for a moment about the systematic, widespread, and institutionalized, and why that's such a problem?
Sure. So it goes back to documentation, right? I think the ill treatment that kids face, whether it's physical abuse, psychological abuse, due process denials, denying lawyers, etc. I think of Palestinian human rights issues that are sort of inherent in the occupation. These are some of the most well documented. There are, just in the past 5 years, there's a dozen reports from Human Rights Watch, from Amnesty International, from DCI Palestine, from UNICEF, B'Tselem, an Israeli human rights organization, and it's overly documented. Sort of the nature of arrests of children and their prosecution in the military court system. So what happened in 2013 is sort of UNICEF came into the child detention sort of realm. Traditionally UNICEF has been very humanitarian focused, protection focused, but I think looking at legal systems around children deprived of their liberty was sort of a little bit outside the scope, at least when it comes to the situation in Palestine. And so the 2013 report was really I think it brought these issues to the international level in a way that might not have happened before. And by saying that these physical violence, ill treatment, the whole range of violations that children face throughout the process of detention by Israeli forces is widespread, systematic, institutionalized, means that it's not something that's just a little bit broken, that there's a bad apple here and there. It really is the motivation of detentions and targeting of Palestinian children to treat them specifically this way for a specific purpose. So I think that, we had been saying that as DCI Palestine since I think about 2002. And so 2013, to have UNICEF sort of say yes, was hugely important. And I think from that point, there was really the international community had done a good job of highlighting the issue and pushing policymakers on it. But I think 2013 was really just a huge step forward, not in stopping violations, but in awareness around violations and pushing the issues towards policymakers in a real way, because now UNICEF had really come out strongly behind the documentation that did exist.
Right. Right. Well, and one of the things we heard Farah say is about how even when things are written into the military law, so these children are under the military code in the occupied Palestinian territories, but even when things are written into the law, they're actually not being applied.
Not totally, yeah, not totally. There's a lot of tactics and policies that are being conducted to use such exceptions of the law as the general practices in like as a routine by the police forces and military forces. I think that what Brad said also earlier, that I think, in my opinion, also that there's no way to achieve justice inside such court halls because the system is all built in a way that to control, rather to achieve such justice, or to have a truth, or to gain the justice as it's supposed to be. I think that it's not logical to talk about justice when you have the one who is responsible of the arrest is the same body of the one who is interrogating the children, and at the end of the day the same body is sentencing such children and put them back in the prison. So I think that such different faces are working to achieve one target, and they are all different faces for the same coin, and gaining such justice inside such courts. When I'm talking about military courts, I'm talking about caravans, and I'm talking about military figures, military judge, military prosecution, military translator, and military and military, and the prison administrative people, and at the end of the day those figures are supposed to achieve justice. I don't think so that justice can be gained inside such halls, and I think that the fair trial standards are very, very far away from the Israeli military courts, and I think also that as we saw yesterday, that Ahid Tamimi was released after spending 8 months inside the prison. Ahid talked yesterday about the very hard circumstances of the detention itself, inside the cells, inside the prisons, and the behavior of the Israeli prison administrative, the attitude, and all of the environmental circumstances that the prisoners and the children specifically live in. The circumstances can change, and from bad to worst. I think during the interrogation, the very temporary detention cells before bringing the children to the court has a lot of bad conditions, very unclean, and very tight, and not the condition that a child need to be put in.
And I would just add too, I think it's important to note, like we're talking a lot about is detention, and international law when it comes to children, juvenile justice standards that are universally applicable say that children should be detained only as a measure of last resort for the shortest period of time possible. And so what you have in the military detention system is pretrial detention as the norm. So kids rarely get bail. So I think it's important to point that out, because when we say widespread, systematic, and institutionalized, it really is all of these different components that are just the norm. We talked a little bit about it. There's the exception becomes the norm, and I think in the West Bank that's very true. But I think that it's most clear in East Jerusalem, where you have Israeli authorities applying Israeli civilian law through the unlawful annexation of East Jerusalem. Israeli authorities apply civilian law to Palestinian population in East Jerusalem. So in theory, right, Palestinian children have increased rights because that civilian law has those rights. But what we see very clearly is that in practice, those rights don't exist because Israeli authorities use the exceptions almost all the time to prevent children from having the additional rights that they should.
And also,
right.
Yeah, and also criminalizing the children is the target at the end of the day of such forces, because we see also that a lot of children being detained without even being indicted at the end of the day. So also this kind of practice is very usually conducted also in East Jerusalem on the Palestinian children. A lot of arrests that continued for a couple of days of interrogation, and then the children are being released with conditions such bails and home arrests, and are not being indicted at the end of the day. It says something about the criminalization instead of from the system itself. And also we don't have enough time to talk about the impact about the home arrests. Like, even when the court wants to deal with the children, with the child detention as the actual prison and detention of the child as the last result, the other option is to release him in a condition, as one of the conditions is the home arrest. But also the home arrest itself has a lot of negativity on the children and the families. But we don't have enough time to explain more.
Right. I'm sensitive to the fact we have about 10 more minutes, and we have quite a few questions that have come in. One of the things I just wanted to emphasize, as you were talking about Ofer and some of the processes in the actual cases when they go to trial or to court, the military court, I traveled and was hosted by Defense for Children International with a lawyer from International Prison Fellowship. And the way he described the court case in Ofer prison is, he said it's a horse and pony show. I mean, the conviction ratio, let me ask, what is the conviction ratio for children who are brought to trial in the military courts?
It can start from 1 month till usually 12.
No, but I mean, how many, like, what's the conviction ratio of how many are determined to be guilty versus not guilty?
The percentage is it's another issue, big issue that
I mean, my understanding is 99% of the children who are accused of throwing stones are convicted of throwing stones.
Yeah, but I need to emphasize that this percentage don't exactly illustrate the fact that in the end of the day, such children is guilty, in fact guilty, because the convictions rate is high. That's because of the plea bargaining that at the end of the day the children choose to take and to accept, because this is the fastest way to get away out of the system.
Well, and I'm using ratio. Sorry, Brad. I'm using the conviction ratio as an example of proof that the children are not getting a fair trial. Is why I was raising that point.
And just to add concrete numbers, I think from 2015 to 2017, of the close to 300 cases, I don't have it at the top of my head, but I know that there were only 2 cases where we had the charges dropped against 2 children, and the other however many hundred kids were all, pled guilty as a plea agreement. And as Farah said, it's not indicative of, so I think guilt or innocence, kids get arrested, whether they've done something or not. Kids do throw stones, kids don't throw stones. It actually doesn't seem to matter so much with who ends up in the military courts. The thing about who ends up in the military courts tends to be children living in communities near settlements, near the separation wall, near military bases, kids that the infrastructure of the occupation impacts their lives, right? Those are the communities that are targeted for arrest. So,
Right. Well, Brad, we would be remiss if we had this whole conversation and didn't talk about the legislation in Congress having been proposed by Betty McCollum. But can you give us a snapshot of what's happening in the U.S. and how we're responding to these realities?
Sure. So we, as Defense for Children International-Palestine, we partnered with American Friends Service Committee on a campaign called No Age to Your Child campaign. We launched it in June 2015, and the goal was to bring this specific issue of Palestinian children in Israeli military detention to policymakers, to Congress. There was a sense that it could be futile, but we, as a Palestinian organization, had never done a good job of engaging with American policymakers, so we wanted to give it a go and see where we could get. So we had some success in 2015 with 19 members of Congress signing on to a letter led by Representative Betty McCollum, and then we had a follow-up letter in 2016 with 20 members that signed on. So looking at the 2016 election and incoming Trump administration, we wanted to have something that was very concrete, practical, and provided a strong message on these issues. Saying that there needs to be a rights-based discourse, talking about ill treatment, torture, and America's role in supporting that through military aid. So Representative McCollum introduced in November of last year a bill. It's the number is HR 4391, and the bill seeks to ensure that no U.S. Funds that are provided to the government of Israel through the military aid financing package are used to support the ill treatment, torture, denial of lawyers, sort of a list of prohibited practices under international humanitarian law and human rights law. Essentially ensure that U.S. funds aren't supporting those practices. It doesn't cut funds. It doesn't make the funding conditional on the practices happening. Essentially, Israel's completely free to continue abuses. So in a sense, this is, I think, it shows where we are when it comes to these violations. Hopefully we would have been further along after 50 years of occupation in talking about actual violations that impact Palestinians. But I think this bill, while it's a wonderful success in a huge moment as the first ever bill introduced around Palestinian rights in Congress, it does show sort of where that discussion is and how much further we need to build to have a really strong impact. So the bill, we have a lot of resources as part of the campaign on the bill. So it's www.nowagetoreachild.org. There's a whole page that has a number of different pieces on the bill specifically. It has 30 supporters in Congress at the moment. And, we're working to build more every day and working with CMEP to bring new members of Congress on board. And I think that's what's exciting about us partnering with CMEP on this webinar, but also on the Document Detention campaign, is that the donations to the fundraising campaign go to helping us document violations on the ground, and then also bring those to members of Congress in Washington through joint advocacy. So you're supporting a very comprehensive package essentially, and much needed to continue pushing both on the bill, but also just to bring people around on what's actually happening on the ground and what it means to be a Palestinian child living under 50 years of military occupation.
That's right. And we're just so grateful for your work. I mean, as you mentioned, you have been doing this on the ground, documenting these realities since how long? When did DCI Palestine start?
1991.
Since 1991, and what critical work and how necessary. And, it's devastating that often it feels like the situation and these realities are getting worse as opposed to getting better. And so our commitment is to try to raise awareness about them, but to address them from a policy perspective in the US. We, as you know, but we just honored Betty McCollum with our congressional award at our National Advocacy Summit, and Still We Rise, because we feel like it's just so courageous for her to bring forward this legislation, calling on the U.S. to not be complicit in the realities of these abuses towards Palestinian children. We're really grateful to Defense for Children International-Palestine, to Brad, Farah. Thank you so much for being with us. There's so many things we could talk about that relate to the issue of Palestinian children being detained by the Israeli military. Churches for Middle East Peace is committed to addressing this issue. We hope you'll join us in our Document Detention campaign. You can learn more about that at our website at www.cmep.org, cmep.org. We feel that the issue of child detentions in the Palestinian territories is devastating to the next generation of youth growing up in the East Jerusalem, West Bank, and the realities affecting them are things we want to address. So please join us.